Now we're on page 5 of the resale condominium property purchase contract, and we're continuing on with the different conditions that can be added there. 8.1c would be a property inspection condition. So it simply means if you, the buyer, are not happy with the inspection, you can walk away from it. And we don't select that a property inspection schedule will be attached. So we just check off the box no. Sale of a buyer's home condition. Well, obviously if you have to sell one home to buy another one, you can add that as a condition. And then under 8.1e, under additional buyer's conditions, we add in here that this contract is subject to the buyer's approval of obtaining financing at the terms and conditions acceptable to the buyer. And then on top of that you can put down subject to the buyer's lawyer's approval of the terms and conditions of this contract and financing. And then put down a condition date, again about 2 weeks out. The seller's conditions are whatever they might be, and there's a specific date for that. 8.3, if there's an assumption of the mortgage, the lender has to confirm that it'll be assumable by the buyer by a certain date. And since that condition is of mutual benefit, it cannot be waived unilaterally. Both parties have to agree to that. 8.4, the buyer's conditions are sole benefit for the buyer, sellers for the seller. That's normal. 8.5, the buyer and seller may unilaterally waive or acknowledge their conditions have been satisfied. If the notice is not given, then the contract is ended immediately following that condition date, which simply means if you don't send in a written waiver, the contract is ended. Now 8.6 relates to these as well. In this case, it says the buyer and seller may give written notice to the other party on or before the condition day, advising that a condition will not be waived, has not been satisfied, or will not be satisfied. And if that notice is given, then the contract is ended. Now that kind of is if you're doing it ahead of the contract date. Let's take a look at 9, which is the remedies and disputes section of the contract. In 9.1, if either party refuses to complete the contract according to the terms, then the other party may pursue all available remedies. Now the seller can include keeping the deposits, claiming additional damages, and both the seller and the buyer can claim reasonable costs, including any legal fees and disbursements. 9.2, if the seller has to restore the title to the property, then enforce a lien or regain possession due to the buyer's default, then the buyer will pay the seller's reasonable costs, including all these legal fees and disbursements for the that are incurred by the solicitor and client. Now, number 10. This is advice and disclosure. And this is important here. It says, please note this contract is to be used only for condominium units for resale, which are not covered by sections 12 and 13 of the Condominium Property Act. Alright, we'll continue on here. 10.1, contract is intended to be a legal binding obligation. Both parties should read it carefully and get any advice before signing. Any representations to the measurement of the property are only approximations and may not be accurate, and the buyer may wish to obtain an independent party to do that. 10.3, unless there's written consent, something different, the seller's brokerage represents the seller and has no fiduciary duties for the buyer, and likewise for the buyer represents the buyer and has no fiduciary relationship with the seller. Number 10.4, the seller and the seller's brokerage have a signed listing contract, and then the seller is going to direct the seller's lawyer to honor the terms of that contract and to close according to the irrevocable assignment of the purchase price contained in the listing contract. Number 10.5, the buyer and lawyer agree the sale and other related information may be retained and disclosed by the brokerage, the real estate boards, for closing, reporting, appraisal, and statistical purposes. That's done very, very often, if not 100% of the time. The contract may be signed and sent by fax. That's as effective as delivering the original copy. That's why in 7.6 we've also added the contract may be sent via email, and that's as effective as signing and delivering the original copy. And it's binding. 10.7, dower consent might be required if the title is only in one name and the registered owner is legally married. So again, dower does come into play sometimes.